morning, Judge. My name is Bill Davell. We're representing the intervener, Pirtle, who was the successful contractor on this project. We adopt and agree with the position that's been taken by the respondent. Judge, based on the documents that have been exchanged by the parties, based upon the discovery that's been taken, multiple depositions of key witnesses, there's been no conduct on the part of the school board that rises to the level of arbitrary and capricious. And we would ask the court today to focus the evidence that it hears on that issue. Does the action of the school board in awarding this contract to Pirtle rise to the level of arbitrary and capricious? Because that's the law, and that's really what we're governed by today. I'd like to address a procedural issue. Judge, it's really not my preference nor my litigation style to repeatedly interrupt a presentation or a witness's testimony with objections. But Judge, based on what we've seen so far, the types of questions and the materials that have been proposed to this court as alleged evidence, it appears that we, and I believe also the school board, are going to necessarily have to protect and preserve our position by making objections today, many more than are necessary in a normal proceeding. And that's because they are planning to offer testimony in two areas, Judge, which have been mentioned by the school board attorney that you need to be aware of up front. First of all, they're planning, and it's clear from the opening statement, to try to bring evidence before this court on an issue that has been waived as a matter of law. Secondly, they're planning to bring issues before this court, as just now mentioned by the school board attorney, that are completely irrelevant to this proceeding and to this particular award. On the issue of waiver, Judge, this is a statutory waiver that they have admitted to. Florida Statute 120.573B provides that the time frame for protesting a proposed award of a contract, that's why we're here today, protesting an award of a contract, and that statute contains an additional provision, and that's very, very important with respect to the objections we'll be making if the petitioner plans on going down the path that he's laid out in his opening statement. This is a very important provision, Judge. I'd like to read it slowly into the record. With respect to a protest of the terms, the conditions, and specifications contained in the solicitation, including any provisions governing the methods, the ranking of bids, proposals or replies, awarding contracts, reserving rights of further negotiation or modifying or amending any contract, the notice of protest shall be filed in writing within 72 hours of posting of that solicitation. There's no dispute. In fact, the petitioner admitted in response to requests for admissions that they did not challenge the terms of this RFQ within 72 hours. In fact, they never challenged the terms of this RFQ. Setting that statute in place now, knowing that there's a known waiver that's been admitted to, if you reflect back on about half of what they've just said in their opening, they are taking the approach of a direct attack on the RFQ itself, when in fact, Judge, the only evidence that should be in front of you today is on the action of the school board, not on the RFQ and its terms themselves. And that's where we'll have to be objecting when the questions come up, and I apologize in advance, but it's necessary. Secondly, to the extent that they challenge these terms of the RFQ, those terms individually that they've already started to bring before this court in opening, those are established terms. They had a right to challenge them, and that would make this protest twofold: challenging the RFQ and its terms, challenging the actions of the school board. But they are severely limited, Judge, by the waiver contained in the statute. The second area that I mentioned that I must be objecting to, as the evidence starts to come in, and you've heard hints of this already in the petitioner's opening statement and mentioned by Mr. Bell, and that's the issue of relevance. Judge, they have so little to go on when it comes to whether the actions of the school board were arbitrary and capricious, that the only way they can try to come before you is by creating an air of suspicion. In other words, they're trying to think of anything and everything they can make the school board look bad generally on, and then try to pile that up enough so that you can question this award. Most of this is contained on these irrelevant issues in the motion to strike that was filed by the respondent, the school board, which at the time you denied, but you said you would revisit as we came into this hearing, where the school board sought to challenge and strike multitudes of paragraphs that are irrelevant in the amended protest. They've claimed, for example, that my client Pirtle and other contractors contributed to re-election campaigns of the board members. Any testimony that's elicited today that goes to campaign contributions should be stopped immediately. That has no relevance to arbitrary and capricious action on behalf of the school board. Secondly, we learned this Monday, and today is Wednesday, that they're planning to bring in a witness that's going to testify that one of the board members used school board property for fundraising activities. That has no relevance to this protest. So that witness, if he begins to be questioned in that regard, should be stopped immediately. Third, we learned yesterday that their first witness that they're going to call this morning is another local contractor, and his testimony is simply going to be that he's complaining that the school board hasn't given him enough work. That has no relevance to whether the school board's action in this matter was arbitrary and capricious. None of this has anything to do with a rational basis of attacking the actions of the school board. And again, I say to the court respectfully, anything to do with the RFQ and any terms in the RFQ and the interpretation of any terms in the RFQ has been waived. The only thing that really should come into evidence today is evidence pertaining to actions of the school board in applying the RFQ's terms and determining the court's determination whether those actions of the school board in applying the terms of the RFQ were arbitrary and capricious. You know more than anybody here knows the standard, and that's the standard for review. This is a bid protest. Your charge is to analyze the actions of the school board. Were those actions arbitrary and capricious as they pertain to this contract? As mentioned by Mr. Griffin, the school board attorney, and as you've already seen in opening, they've spent a substantial amount of their time in even bringing this before you in opening, talking about contracts that go all the way back to 2002 and several versions of the RFQ. That has no time or place here in determining whether the actions here in this limited time frame dealing with an RFQ that has not been challenged, whether the actions of the school board and the steps they took were arbitrary and capricious. And we would request that as you listen to the evidence, you apply that standard, which is clearly the law, and the judge, you streamline this hearing, not like the depositions that have taken place. You streamline this hearing by requiring the petitioner to stay focused on what has not been waived and what is relevant to this bid protest. Thank you.